Thank you for visiting Hill and Ponton's Social Security Disability blog. I'm Natalia Jofre. I'm the Social Security Section Director.
And I am Shelly Mark. I am the Senior Social Security Attorney.
So we're talking about continuing disability reviews, cessation cases. So quick recap. Social Security has determined that you're no longer disabled.
Right.
They stop your benefits. You file an appeal. You may request for your benefits to continue. And then about 3 months in, they send you this little notice that says you are going to be scheduled for a hearing, or you are eligible to have a hearing. I think that now they're saying they're going to have it, and then it's up to the person if they want to keep it or deny it. That's how they have, because they've changed it several times.
Right. Yeah, I think that's it.
So they send you a hearing notice.
Right.
What's your opinion on those hearings, Shelly? Shelly Mark.
We were very open-minded to begin with when we were taking more cessation cases, and we attended several of these hearings for our clients, and I formed the opinion that it was in our clients' best interest to waive our appearance at these informal hearings and go ahead and file a request for a hearing with a judge and then pursue it in that way. We have not been successful in any of the informal hearings. These are done at the Social Security office. These are not hearings that are actual hearings, nor are they conducted by judges, nor are they conducted by attorneys. These are like claims adjudicators that are just listening to us tell them why you feel like you're still disabled. In addition to that, there's no new evidence usually. So it's everything that's already been presented from when they found you to have medical improvement. Right. And then a month later or 2 months later, they have an informal hearing, which doesn't make a whole lot of sense because there hasn't been any changes.
Right. So no evidence has been developed. You haven't been able to submit anything
to a doctor.
Right.
And another thing that I felt as an advocate that was highly inefficient was that they didn't give me an opportunity to review anything before I got to the informal hearing. So while I was there, they were basically showing me the records. It was a little bit of a mess.
Yeah. So they're pretty pointless.
They are. Yes.
So we want to just make sure you
slow it down. You know?
Yeah, right. Because what they'll do is they'll say, okay, you have a hearing on this date, and you can keep it or waive it, and then you keep it, and then you actually have to wait for that, and then you go to it, and then they say, okay, now that we had this hearing where nothing really happened,
right,
it's going to take an additional 60 to 90 days for you to get a decision.
Exactly.
Whereas if you waive it, then you can just get that processed more quickly and get through that level more quickly.
Right.
But just to clarify that this is the informal hearing held by the Office of Disability Determinations at the Social Security office. This is not when you file a request for hearing and go to an actual hearing at the hearing office before an administrative law judge. So right. Make sure and understand that there is a huge difference. And we'll talk more about that administrative law judge's hearing in a different blog. Because that merits its own attention.
Definitely. The hearing with the administrative law judge is definitely not pointless. That one is very important.
Or when you want to miss for that matter.
Definitely.
Okay, great. Well, thanks for joining us. If you have any questions, feel free to visit our website or call our office.
Thank you.